Okay, thank you.
So now let me go on with my questions. So for me, while I understand, to be honest, that this is a vested rights hearing, I'm struggling to understand what exactly is the scope of vested rights. That is, what does that mean? How broad is the definition of vested rights? I think kind of in a hierarchy is, does it mean the applicant had the right to grade and excavate in the 60s? Does it mean they had the right to build and develop on these lots in the 60s? Does it mean that once they had vested rights, they have the right to continue to keep these lots clear of vegetation forever, regardless of whether there was ESHA on it or not? And so that's kind of what I'm groping for. And I think the staff, in one of the staff reports, referenced the California Supreme Court decision called AFCO, which said that if a property owner has performed substantial work and incurred substantial liabilities in good faith reliance upon a permit issued by the government, he acquires a vested right to complete that construction in accordance with the terms of the permit. Now that would be kind of logical and clear, except there's no permit here.
There's no permit.
So while AFCO takes you down a path and says, great, no problem, vested rights, go do what you want for the rest of your life, I'm trying to understand where the smoking gun is, and I will ask you in a second. So I'm just number one want to put on the record that the staff seems to have disagreements among themselves, whether a grading permit, the staff says one thing, council says another, whether no, they didn't need grading, yes, they needed excavation, no, yes. I think it's clear that at least to me in the 1960s, they could grade this property. I think there's a different question now whether that means that in perpetuity you could keep scraping this ground because there's a reliance on an implicit permit, not an actual permit, of we could build on this. It kind of means that the extent of the vested right is determined by the terms and conditions of the permit or approval on which the owner relied on before the law that governs the project was changed. And I think that's kind of what we're discussing. And so I'm just trying to understand what was the good faith reliance by the claimant on a representation that the project is approved and legal. So can I ask the applicant, is that logic at least?
Yes, I mean, I think the good faith reliance is one can rely on many kinds of government authorizations. Right. One thing that they relied on was the Orange County Code in effect at the time, which basically gave them an authorization to grade that property, and it was in reliance upon that they expended the sums. Now, in the AFCO case, which is one of the seminal cases related to vested rights, they do use the language of reliance on a permit. But there are other cases in the body of case law which makes it clear, and I think even in the staff report, it is, when you look at all of the cases, the standard is whether or not there's been good faith reliance upon governmental approvals. And so you can rely upon, I would argue that in effect, the Orange County Code was an authorization and was something that they relied on. And there's case law that indicates that the issue is whether or not they had all applicable governmental approvals and whether it was legal at the time. In this case, there were no applicable governmental approvals. They relied on the Orange County Code, and I think that would meet the standards of AFCO.
Let me just also ask if you'd agree that an applicant can't rely on an approval that's not been given, correct? Do you believe the applicant had permission to build a house?
No, because that was not no, we don't think they did have permission to build a house.
Okay.
And they didn't build a house.
So let me work backwards. Right. Do you believe the applicant, based on this 1960 grading, had permission to keep the pads graded for 48 years?
I think they had a right to maintain the pads over the period of time consistent with the requirements for maintenance applicable during any period of maintenance. So, for example, today, they would not be able to go out and grade the pads without going and regrade the pads without getting a grading permit from Orange County and a coastal development permit from this commission. But they could maintain the pads to the extent that what they did falls within the repair and maintenance exemption, so they could do hand clearing of invasives, they could do invasive removal. So we have to comply with the laws that are in effect today for maintaining the pad, which means we can't go grade them today. But there is a repair and maintenance exemption that we would be able to avail ourselves of, and we would.
So let me just go down this path one level deeper. Under what basis in law do you believe your applicant has the ability to maintain it forever, given the change in laws? Is it AFCO or something else?
It's AFCO. I mean, basically they have, the development was the grading that was completed on or about 1960. They have a right to maintain that development. It's basically their property right. I think if you look at the Coastal Act, it basically says that we do not have to get a coastal development permit as long as it's substantially the same. And so we're allowed to maintain it substantially the same without getting a coastal development permit, as long as we fall within the exemptions.
Right, and and again, the approval here is an implicit approval, not a written approval. Is that correct?
Right. It's it's a government authorization.
Can you just help me through the other side of this argument? Thank you, Mr. Zuber. Very helpful.
Thank you very much.
Any comment, counsel? Either one or none. If you have no comment, it's okay.
I think that the issue is understanding the difference between, we don't disagree that in order to do the work they want to do today, they'd have to comply with the Coastal Act, meaning any non-exempt development they did out there would require a CDP. So I think that's a correct statement of the law.
Well, I guess my question was something a little more fundamental, is that they performed substantial work and incurred liabilities in good faith upon reliance on a permit or implicit permit they had in the 60s. That's
their claim.
That's their argument. I'm asking you, do you just fundamentally disagree, or?
Well, we don't agree that that's what they did. That's why it's your decision to determine that. That would be
the crux of the matter?
Yes.
Okay, thank you. I'm done.
Okay, thank you.
Madam Chair.
Commissioner?
Madam Chair.
Commissioners?
Madam Chair.
Director Dutton?
Yes, I want to make sure that we understand it, because I think Commissioner Blank did hit it right on. They needed to conduct this work, incur these expenses in reliance on some sort of approval. They're saying that there was implicit approval because there was no requirement. Well, they haven't shown us that there wasn't a requirement for a permit, and when you think about the fact that there are 14 pads out there, and there are 2 lots, 2 parcels, you can't tell me that they had some sort of implicit approval to grade 14 pads on 2 parcels. So we think that there is a burden here that they haven't met to show that they had implicit or explicit approvals from the local government to undertake the grading.
Okay, thank you.